Companies have an obligation to meet the relevant conflict mineral requirements for determining the origin of minerals in their supply chains. It's important to remember that the regulations apply not only to publicly traded companies that manufacture their own products, but also those who contract manufacturing and who are in the supply chain of publicly traded companies. Prior to the SEC's April 7, 2017 public statement, companies were required to follow a three-step process to comply with the SEC's regulations. These steps are laid out in the SEC's provided flowchart. Currently, only the first two steps are mandatory. Following a court's determination that certain disclosure requirements of the Act violate the First Amendment of the U.S. Constitution, the agency has stated it will not enforce the third step, Section 1.01c of Form SD. This includes requirement that companies report to the SEC and state on their websites if any of their products have not been found to be DRC conflict-free. Companies may choose to voluntarily follow the entire three-step process already in place based on internal policy decisions. In that event, employees responsible for supply chain management will be required, not by law but by their employer, to follow Step 3 as appropriate. For these reasons, we continue to use the flowchart. Step 1 of the process involves a determination whether the regulations apply to your company at all, which is checking if products contain conflict minerals. A company is governed by the Act if any of its products or product components contain the specified minerals that are necessary to its production or functionality. Thus, to perform Step 1, you ask two questions. Do any of our products or components contain conflict minerals? And are the minerals necessary to the functionality or production of the product? If it is determined that there are no conflict minerals, or any conflict minerals are not necessary to the functionality or manufacturing of the product, then no action is required. If, on the other hand, there are conflict minerals and they are necessary, then the company must go on to Step 2. Step 2 is known as a Reasonable Country of Origin Inquiry, or RCOI. To conduct the RCOI essentially involves asking two additional questions. Did the minerals come from recycled or scrap sources? And if not, did the newly mined minerals come from the DRC or any of the specified adjoining countries? If, after the RCOI, you know or reasonably believe newly mined minerals might have come from the specific conflict countries, then, under the Act as originally designed, you would move on to Step 3. Step 3, conduct due diligence, is not presently enforced by the SEC, but may be required by your company's conflict mineral policies. It involves an inquiry into the sources and chain of custody of conflict minerals. If, after due diligence is performed, you know or have reason to believe that your conflict minerals come from a covered country and not from a recycled or scrap source, you would complete a detailed conflict minerals report, a CMR, as described in Form SD. Now let's focus on Form SD. The form should contain a brief description of the RCOI and the resulting findings of the mineral's origin. The form refers to this brief description as a Conflict Minerals Disclosure, or CMD, and must be filed with Form SD annually. If your employer chooses to voluntarily follow the SEC's former requirements, then you will proceed to Step 3. The purpose of performing the due diligence of Step 3 is to determine whether there is reason to believe the minerals are sourced from the DRC zone or are DRC conflict-free or DRC undeterminable. Again, although the SEC is not enforcing the due diligence provisions, and companies are not required to disclose whether or not the minerals are conflict-free or undeterminable, some companies voluntarily include a conflict-free disclosure with Form SD. The due diligence can be done using a nationally or internationally recognized framework. For example, the Organization for Economic Cooperation and Development, or OECD, Due Diligence Guidance for Responsible Supply Chains of Minerals from Conflict-Affected and High-Risk Areas can help companies avoid contributing to conflict by advising them on their mineral and metal purchasing decisions. There are 5 recommended steps in the OECD framework. First, establish strong company management systems. For example, adopt and clearly communicate to suppliers and the public what the company policy is for sourcing minerals from conflict-affected and high-risk areas. Next, you should identify and assess risks in the supply chain. You then must design and implement a strategy to respond to identified risks. For example, report findings of supply chain risk assessments to the company's designated senior management. Then, carry out an independent third-party audit of the supply chain due diligence at identified points in the supply chain. Finally, you should report annually on supply chain due diligence. If the due diligence results indicate that conflict minerals are not from covered countries or are not from scrap or recycled sources, it should be documented as part of the company's due diligence in the CMR as defined in Form SD. Again, neither the due diligence nor the CMR is presently required for Form SD filing. Rather, Form SD need only include the CMD in a brief description, as described in Step 2. Pursuant to a U.S. Court of Appeals ruling, a company cannot be required to declare whether or not its products are DRC conflict-free. If, however, a company chooses voluntarily to declare in the Form SD filing that its products are conflict-free, it must substantiate the declaration by obtaining an independent private sector audit, or IPSA. No company is legally obligated to perform an IPSA for the Form SD filing unless it elects voluntarily to describe its products as DRC conflict-free. The IPSA consists of two parts. One part states the company's due diligence framework is consistent with a recognized national or internal due diligence framework. The other part declares that the due diligence process described in the CMR is actually undertaken by the company. Many companies have developed a responsible sourcing policy. As an employee involved in the company's supply chain management, you need to understand how your company's policies and procedures shape your role in adhering to conflict minerals provisions.